Mr. Chairman, what is...
Gentleman is not recognized.
There's no rule nor precedent for anybody being a witness and then getting to come up and question. And so
I have ruled
we would. The point of order is he's inappropriate to be up here asking questions. How much money do you have to give to get to do that?
Jerry. And never has it been more applicable. His name is Jerry. His name is Jerry Nadler.
Who?
Jerry Nadler.
What are we talking about?
Jerry Nadler. Viva Frei, Montreal litigator turned YouTuber. I do vlogs. It is a play on the word vlog, like a video blog, and vlog. This whole impeachment inquiry has become the vlog that just keeps on vlogging. I've done a ton of videos on the subject. I'll link a playlist right here and at the end of this video, but I've done videos explaining what the emolument clause is. I've done vlogs explaining what the quid pro quo is and was, breaking down the actual transcript of the call between Trump and Zelensky, breaking down the constitutional scholars' expert testimony. We've gone into constitutional issues. We've gone into historical issues. We even went over the impeachment of Andrew Johnson, an impeachment that failed by only one vote in the Senate. And the other day I did a video breaking down the parliamentary procedure, or the absence thereof, in the context of these impeachment inquiry hearings. And then we came across this gem of a question. A witness, Barry Berke, testifying as a witness, then literally getting up, joining the committee to cross-examine other witnesses. The whole debacle has had a ton of people up in arms, including the minority Republicans, and has had other people asking a lot of questions as to whether or not this is even permissible to begin with. And in this video, I'm going to break it down and explain it, and you can come to your own conclusions. But first, a word from my sponsor, SuttonDigitalMarketing.com. They are one of the few companies with the courage to actually sponsor my type of content, legal, which touches on politics, which people tend to want to avoid. They specialize in SEO, and from what I'm told, they've helped over 150 lawyers reach the #1 Google rank for 800 keywords. True anecdote from my own practice, I had a client who specialized in online immigration services, and being top ranked for the relevant Google keywords was their #1 source of leads. There are certain tricks to all of this, not everybody knows them, not everybody has time to do them, and that is where Sutton Digital Marketing might be of use to you as a lawyer or a law firm. I'm told the rates are affordable, and in any event, you'll get 50% off your first month if you go to SuttonDigitalMarketing.com/Viva. That's SuttonDigitalMarketing.com/Viva. Back to the video. We have another day of impeachment inquiry hearings, another day of experts testifying on the one hand as to why Trump did in fact commit an impeachable offense, and on the other hand, why Trump did not commit an impeachable offense. And to that end, two of the witnesses we had on this, I think it was what day was it of the hearing? Whatever, I've absolutely totally lost track of what day we are on, but on this particular day, two of the relevant witnesses that we had testifying were Barry Berke and Stephen Castor. The two of them are lawyers, Berke for the Democrats, Castor for the Republicans, and they're both going over the evidence, explaining why, in their view, there was an argument for and against impeaching Donald Trump. Barry Berke gives his 30-minute opening statement and then gets up and proceeds to join the committee to cross-examine Castor, the lawyer for the Republicans. And that is when the proverbial poo-poo hits the fan.
25th, and how many times?
I didn't look at Twitter. I try to stay off Twitter lately.
Mr. Chairman.
Well, sir,
Mr. Chairman, parliamentary inquiry.
The gentleman is not recognized for parliamentary inquiry.
Mr. Chairman, what is...
Gentleman is not recognized. The gentleman, Mr. Berke, has the time.
And I don't want to go into Barry Berke's testimony in detail. It's not the purpose of this video. Suffice just to summarize 2 points. The one major point that Barry Berke raises in his testimony that I've addressed in previous vlogs is the big argument on the for impeachment side. It's actually more of a response to one of the major defenses of the anti-impeachment arguments, to the effect that Trump released the aid, didn't actually require anything from Zelensky, and specifically said to Gordon Sondland, no quid pro quo, I want nothing, I just want them to do the right thing. And Barry Berke's response to this is that all of this otherwise exculpatory information occurred after the fact. It occurred after the story broke, and it was just the administration trying to cover its tracks. Okay, it's a valid point, but it's a valid point that presupposes intent and presupposes that a wrong was committed in the first place that required covering up. But that is the argument. Come to your own conclusions. The second thing that I noticed from Barry Berke's testimony, and also from Noah Feldman's testimony, a lot of referencing our kids and our grandkids and having to answer to them. As a lawyer, these types of emotional arguments always raise red flags. And I've said this in previous vlogs, but invoking benevolent causes, invoking the children, always leads me to believe that their argument is a little bit weak. It's an emotional distraction from the substance of the argument.
My young son asked me a question. Like many questions by young children, it had a certain clarity. Whether we want our children and grandchildren to live in a country, future generations will be the judge.
Which leads me to another funny anecdote of my practice. I was once in front of a judge. We had a witness testifying. I had spent 2-3 days prepping the witness. And the second we get up in front of the judge and the witness is being cross-examined, they immediately reflexively start invoking their children. They have a wife, they have kids, they wouldn't lie under oath. And they said it so many times it actually caused the judge to intervene and say, look, I understand you have a wife and kids. That doesn't mean that I'm going to give you more credibility than the other guy. But getting back to the issue, Barry Berke gives his 30 minutes opening statement, then proceeds to get up, join the committee to cross-examine Stephen Castor. How, who, what, when, what?
What?
We're going to ignore the rules
We are
and
not-
allow witnesses to ask the questions, then
Gentlemen will
how many other rules are you just going to disregard?
Gentlemen will suspend. Gentlemen will.
Well, I made a point of order, and you won't rule on it.
I have not heard a point of order. If the gentleman has a stated point.
Mr. Chairman, point of
Gentleman
order.
has a point of order. He'll state your point of order.
There's no rule nor precedent for anybody being a witness and then getting
That is
to
not
come
a
up
point
and
of order.
question. And so
I have ruled that-
we would.
that
The
is
point
not-
of order is he's inappropriate to be up here asking questions.
That is not a point of order. He's here in accordance with Rule 66.
How much money do you have to give to get to do that?
I have ruled the gentleman has the time pursuant to Rule 660.
Jerry Nadler, the chairperson with the gavel, who we know has a propensity to banging the gavel, references a Resolution 660 to explain what is going on. What is House Resolution 660? H-Res 660 in the House of Representatives, U.S., October 31st, 2019, resolution that the Permanent Select Committee on Intelligence and the Committees on Financial Services, Foreign Affairs, the Judiciary, Oversight and Reform, and Ways and Means are directed to continue their ongoing investigation as part of their existing House of Representatives inquiry into whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Donald John Trump, President of the United States of America. H-Res 660 basically gives the House the power to inquire into whether or not Donald Trump should be impeached, and it sets out the rules for doing it. Not to be mistaken with the parliamentary procedure, the rules for the inquiry. For the purposes of continuing the investigation described in the first section of this resolution, the Permanent Select Committee on Intelligence, referred to in this resolution as the Permanent Select Committee, is authorized to conduct proceedings pursuant to this resolution as follows. The chair of the Permanent Select Committee shall designate an open hearing or hearings pursuant to this section, and we're going to skim through this because it's 7 pages long and we just want to get to the relevant provisions. Section 2. Notwithstanding Clause 2J2 of Rule 11 of the Rules of House of Representatives, upon recognition by the chair for such purpose, under this paragraph during any hearing designated pursuant to paragraph 1, the chair and ranking minority member of the Permanent Select Committee shall be permitted to question witnesses for equal specified periods of longer than 5 minutes, as determined by the chair. The time available for each period of questioning under this paragraph shall be equal for the chair and the ranking minority member. And the second to last line of that section is what concerns us. Only the chair and ranking minority member or a Permanent Select Committee employee, if yielded to by the chair or ranking minority member, may question witnesses during such periods of questioning. At the conclusion of questioning pursuant to this paragraph, the committee shall proceed with questioning under the 5-minute rule pursuant to Clause 2J2A of Rule 11.
Point of order, Mr. Chairman.
Gentleman will state a point of
Just to
order.
help
Yes,
you, that's
yes,
not
my
Rule
point-
660.
The gentleman will state a point of order if he has one.
Yes, the point of order is this. We operate by rules. If there's nothing specifically in the rule permitting this, we go by precedent. It is unprecedented for a person to come and sit who you've described as a witness to then return to the bench and begin
The
questioning.
gentleman has stated-
That is a point of order.
The gentleman has stated. Is that a point of order? Yes. That is not a point of order, but I will point out that the gentleman has been designated by me to do this questioning. Pursuant to Rule 660, House Resolution 660, which is part of the rules of the House.
Why didn't you do a soliloquy then?
It is in accordance with the rules of the House, and the gentleman's time will resume. Mr. Berke.
Thank you, Mr. Chairman.
And the rest of this resolution is actually very interesting just from a purely academic point of view. Section 3, for example, allows the minority to make a written request to examine certain witnesses. Section 4 specifies that a ranking minority member is authorized with concurrence of the chair, that being Nadler, to issue subpoenas to demand communication of documentation in examinations. It goes on, and if you have an hour to spare, give it a read, because at the very least you can then tell everybody that you have read the full text of H-Res 660.
Knowledge is power.
But it is the second to last line of paragraph 2 of H-Res 660 that allows the chair, that being Nadler, to yield his questioning to a Permanent Select Committee employee. There seems to be no prohibition on that employee to whom the chair yields the questioning to have been a witness themselves. So Nadler, the chair, yields his time to Barry Berke. Who is Barry Berke? Is he a Permanent Select Committee employee? According to the New York Times, the answer is yes. Who is Barry Berke? Judiciary Committee's lawyer will present impeachment case. A New York defense lawyer working for House Democrats, Mr. Berke has been an architect of their impeachment impeachment inquiry. And a little bit further in the same article, it reads as follows. Mr. Berke will not be the only House lawyer publicly presenting on Monday. Daniel S. Goldman of the Intelligence Committee will orally present his panel's 2-month inquiry concluding that Mr. Trump abused his office to pressure Ukraine to investigate his political rivals. Stephen R. Castor will represent Republicans on both the Judiciary and Intelligence panels. But Mr. Berke will be the first witness to speak, setting the tone for the proceeding and a week that could end with the Judiciary Committee voting to recommend impeachment articles. Alright, so Barry Berke is the first witness to testify, and he does for 30 minutes. Then Stephen Castor gives his 30-minute opening testimony, and Nadler, the chair of the committee, yields his questioning of Castor to Barry Berke, a permanent select committee employee. Optics aside, that is the explanation, and it seems to be procedurally justified in accordance with HRES 660.
But one cannot ignore optics.
Now, I have said this multiple times in multiple previous videos. This is not a court of law. This is an impeachment process. It is not a legal process. It is a purely political process. That being said, we can nonetheless stand to learn something from the legal process. In Quebec and Canada, and I suspect it's the same in a great many other jurisdictions, a lawyer ethically cannot take a file if they know that they will be required to testify in the context of that file. There are exceptions to that ethical rule, but that is nonetheless the ethical rule.
Why?
Because it would look very weird if the lawyer in the file started cross-examining themselves as a witness in the context of that file. And this is one of the problems that comes up in the context of self-representation. Incidentally, if you haven't seen my video on whether or not you should represent yourself, I'm going to link it right here and put a link at the end of the video. When someone is representing themselves, it becomes very difficult to examine themselves. They don't literally switch seats in between asking questions and answering questions. They sit there and they just basically end up reciting their file. In the context of self-representation, it's more of a practical problem and not a conflict of interest problem. When a lawyer knows that they're going to be called as a witness in a file, it becomes a conflict of interest issue. Witnesses have different interests than the attorneys representing the parties. And when those interests start overlapping, problems arise. But in the context of the impeachment inquiry, we don't really have the conflict of interest problem. We know that Berke, the attorney for the Democrats, is pro-impeachment. It was evident from his 30 minutes of testimony. But as one of the Republicans points out, why don't we just turn this into a soliloquy? That is sort of what it would turn into. But according to HRES 660, there would be nothing wrong with doing this. And as far as I'm concerned, yielding the questioning to Barry Berke to examine Stephen Castor is absolutely irrelevant in all respects. Optically, it might look a little weird to have one of the witnesses then become the questioner, but it doesn't change anything. It doesn't change anything because Barry Berke, instead of asking the questions, could instead just write them down on a piece of paper for Nadler to read. Now, admittedly, Nadler's cross-examination acumen might be slightly less than that of Barry Berke. And in that sense, you might get a less skilled cross-examination of Castor if Nadler were the one to do it as opposed to Barry Berke. But that sort of attitude is sort of like forcing your adversary to bring their worst player to bat when you know they have a better player on the team. And it's a philosophy of mine that in order to win, you should not rely on the incompetence of your adversary. You should win against your best adversary. So if Nadler thinks Berke can lead a better line of questioning, let him do it. If it's not Barry Berke doing it, it's going to be another relatively competent attorney that works for the Permanent Select Committee. And it makes me think back to another anecdote from my practice where I actually made a motion to disqualify attorneys in a file. The attorneys in the file had not only previously acted against my client, but were currently acting for my client on totally unrelated matters. Try and figure that out. And I made a motion to disqualify on a totally legally justified basis in that a lawyer cannot act against a former client when they've received confidential information from that client in the context of their solicitor-client relationship. I had the extra argument that not only had this occurred in the past, but there were some other related businesses where that attorney was still representing my client in the context of other business dealings. We had to schedule the hearing. The hearing lasted 2 days. It took something like 3 months to get a written judgment, which ultimately dismissed my motion to disqualify. I happen to vehemently disagree with the judgment in law, and it set a very bad precedent as far as I'm concerned that a lawyer can act against a current client if they are doing it in the context of a totally different file. No one is going to convince me that I was not right to seek the disqualification of the attorneys. But the reality is, even if I had succeeded on the motion to disqualify, it would have changed nothing. For all I would know, the very same attorney that I had just gotten disqualified from the file would be sitting there in the backdrop writing the questions for the new lawyer to read. Now, I appreciate that in the context of these impeachment inquiry hearings, there are political points to be gained from raising these types of stinks, and I think the Republicans probably did it. Because on its face, it does look bizarre that a witness gets up and then proceeds to cross-examine other witnesses. And it allows for the following zinger soundbite.
How much money do you have to give to get to do that?
But in my humble opinion, it changes absolutely nothing, and setting aside the political points that may have been gained or lost, it is not a hill to die on by any means. Nor is it determinate as to any corruption of the process. If one were to be looking for corruption of the process, there would be better arguments than this one. Alright, and with that said, because we are heading into the weekend, if anybody is looking for an amazing recipe, how about my homemade poutine? And I said poutine and not Putin. And for those of you who don't know what poutine is, it is a Quebec delicacy that consists of French fries, gravy, cheese curds, and oh my gosh, it's just so delicious. Give that video a watch, drop a comment in the comment section below, share my channel, it helps me grow. If anybody wants some new merch, I've got a new line coming out ASAP. I will send the link out when it's ready. And with that said, now you know your vlog. Peace out. Booyah! Oh, no, but now it looks like I have long hair this way. Yes. Perfect. Oh my gosh, that's perfect. Okay.
What do I do? Just.
No, but you have to go the other way because I'm going to be doing this with this time. Okay, wait, no, but now I can see you. By the way, this is all going in the end of the video.